Hi everyone, welcome to our session. I'm excited to see everyone here today. And today we have a special webinar, a very interesting topic on legal things starting a company in the United States. And LiLing and Aimee will be actually those very knowledgeable and experts who will be addressing this very complex and important topic for startups, especially for the ones who are outside the United States. I have a small update for you. Just 1 second, I'm going to share the screen. So the topic of today is tips for organizing a new US enterprise and legal considerations for early stage financing. Initially, when we were speaking with LiLing and Aimee about starting this webinar, we were thinking how we can help foreign entrepreneurs entering the United States so they don't make simple mistake that can cause them many thousands of costs, like fines or like a cost that can be a big issue for any company, right? And it can be a few thousand, that can be millions of dollars. So the better you register your company, the better your business will be operating. And LiLing and Aimee, they work both at they both corporate lawyers, and they are those people who are heavily involved in basically structuring. And correct me if I'm doing if I'm presenting you incorrectly, so you'll be able to correct me. But you guys are involved in structuring deals and all these financing deals with startups from legal standpoint, and you know from inside all the things that are important for startups to be aware of to make the deal strong and financing without any issues. Am I correct?
Yeah, no, that's a good one. Yeah, I would say that we do everything from formation to exit, because Aimee and I also work on sell-side sort of M&A type deals too. So it's kind of like the full spectrum, and and between us and all the deals we've done throughout the years, we've definitely seen a lot of different things. Interesting dynamics with people, with deals, and so we're happy to share, some of the things that we've seen with you.
Thank you, thank you. So a few words about our community, some update. Why this community exists. Our mission is very simple. We unite English-speaking entrepreneurs to connect globally and get them closer to global capital, customers, and like-minded people. I envision that everyone who is trying to build some value in the world and has access to internet should have equal access to a strong international network, ability to raise capital, ability to get access to the best knowledge so you can build companies and go global. And all that we are giving here for free in order for you guys to start international businesses and create value in the world. And your role, it doesn't mean that it's free is you're doing nothing. You expect it to be active on the community, and if you have a certain expertise and somebody else from any part of the world is asking an advice or help or support, and you have this kind of resource, I encourage you to share it, help each other. This is the best opportunity for you to build your global network, and this is how people in Silicon Valley help each other with and don't ask anything in return, because it works there, and they know they will always get help from each other. Am I right? Am I right?
Yeah, a lot of it is the network, right?
It's all about the network. This is our team, and this is just part of our team. We are a very young community. It's like a 4 months old community, but we already have over 1,000 founders from around the world. And these are the part of our team locally in in about 30 countries. So we have leaders in Go Global Armenia, Go Global Kazakhstan, Canada, Mexico, United States, Australia, Nigeria, Israel, India, Singapore, Korea, and many others. So like we have a truly global, amazing team that is willing to help you to bring your businesses to their markets. And I think this is the best time now to do it. In terms of knowledge, how we help you with knowledge, we bring amazing speakers, experts on certain fields like LiLing and Aimee today. We also had Steve Hoffman, Donna Griffiths, Ilyas Tribulaev, Bob Dorf, Bill Rikers, those people who are experts and with deep knowledge and expertise in their field. And it's very usually hard to get those people attention or even invite them to speak. But at our community, they agreed to come and talk with a global audience for free, just to help people around the world to bring more value and start building businesses. Our next events, in the end of this month, we will have a Russian, we will have Go Global Russia Monthly Founders Meetup. It will be last Friday of the month. And those who speak Russian and spread globally can connect and network and help each other. This one is like limited to Russian audience, and I had a request, and it was very successful. But we are a global community, and we speak all English. This is why we have monthly Go Global World Monthly Founders Meetup in English every first Friday of each month. So the next one will be in September. You can register on Eventbrite, or you can register on our Facebook page, wherever you feel comfortable. If you like our events, this is the link to Eventbrite. You can scan this QR code, or just go on Eventbrite and search for Go Global World. Our partners, we have plenty of partners around the world. For example, GSD Venture Studios, Skolkovo Technopark Business School, Moscow School of Management, Skolkovo, Axis Innovations, and all those guys you see on the screen, they are part of our network, and they are willing to help you in case you have any interest in them. Let us know, we'll connect you directly. How to connect to Go Global World community? Very simple. On Facebook, find our page Go Global World, or scan this QR code. This Facebook page is connected to 90 groups where we have, where in the world we have any startup ecosystem. I believe this is how we can connect with local communities. And we also have a global chats. One global chat we have on Facebook. So you just can search for Go Global World Chat or scan this QR code. We also have Go Global World Chat on Telegram, and of course on LinkedIn, especially for the Western part of the world where they use a lot LinkedIn. We are developing this too, and it's growing fast. This webinar is being recorded and will be published on our YouTube channel, Go Global World. So keep in mind, we are a non-profit community. We have zero budget for anything, for everything. And we are doing this from our heart to help you entrepreneurs, right? And the more likes you put, the more comments you write and start discussions. And the more you share and subscribe, it will help us to be found in search engines faster by other entrepreneurs in different parts of the world. So help us to distribute this content to those people who need this content. We are doing this for free, not for PR, but to help you go global. On my end, that's it. These are my contacts. If you have any questions to me or to our partners or to the speakers or any suggestions, feel free to reach out. And I'm happy to give the floor to our speakers. So LiLing, Aimee, please let us know a bit about yourself, about the company you work for, and let's start on your topic. And one last thing, everyone, everyone, please ask your questions in Q&A section here. If any one of you wants to ask verbally your question, just raise your hand, and I'll let you speak once we finish with the main part of the topic. Thank you.
Yeah, thanks, Daniel. Well, I guess it's good morning from San Francisco over here. Aimee and I are both located in San Francisco. We also work at Reed Smith in their San Francisco office. I'm chair of the Emerging Companies Group, and Aimee is a colleague of mine, and we have worked together for a few years right now on a number of deals, ranging from formation of emerging companies, doing rounds of financing, and then on to actually even sell-side M&A, like I had mentioned earlier, where we're helping companies sort of do their exit in the context of an M&A exit. So, we're happy to be here today, and I'm glad that you could join us. We've got, a few topics that I think are helpful. They're sort of high-level considerations for setting up a company in the US with the view towards receiving funding, and then also sort of thinking about additional considerations for early stage financing. They will be at a pretty high level. I know that some of these sessions can be their own sessions themselves, and you can do a deeper dive, but this sort of format is intended to kind of provide a general overview of what we typically see for early stage companies. With that, I guess I'll turn it over to Aimee.
Hi, everyone, and thank you, LiLing, for the introduction. As LiLing mentioned, me and LiLing work very closely together on a number of corporate matters, including M&A, venture financing, and just general corporate counseling for our clients. So just to kind of give you a brief overview of what we plan to cover today, I'll be providing an introduction into the basic forms in which U.S. businesses are organized for fundraising purposes, and then LiLing will touch upon the details that go into these types of debt and equity securities that are being issued by corporations in terms that are related to venture capital financings. So our first order of business is making the decision to form the entity. So when forming a business, typically the first step is deciding what type of entity is best. So this could be a corporation, this could be a partnership or a limited liability company. And typically this decision is largely dependent on the structure that you're considering, any type of liability or tax implications, as well as management considerations. But based on LiLing and I's experience, corporations are the common form for companies because there is a formal management structure that's in place. There's also a very well-established area of law. This is very familiar with investors, so investors are comfortable with this type of entity. It's also a great avenue if there are future plans to eventually go public. And it's also a very predictable structure and a recognized legal structure within the industry.
Yeah, and I would also add to that a corporation, it's good to incorporate too as you start speaking to investors, because they'll ask you to, or they'll want you and you'll want them to sign an NDA. And in that case, you don't want to be personally liable at that point. You want to have a company sign the NDA instead. So that's one thing that early stage sort of clients think about.
So before forming a corporation, the next decision that you would have to make is determining which state to incorporate. And based on our experience, Delaware is the most common state for incorporation for a variety of reasons. First, in terms of tax implications, there are low franchise taxes. Delaware does not have a corporate income tax that's placed on the business if you do choose to do business in another state. And so a lot of times the clients that LiLing and I work with are based and located in California because that's where we are based. And so typically our client would elect to incorporate in Delaware due to the benefits of that particular state, but then they will then file a foreign qualification in order to be able to do business in California because that is where they are located. Another reason why Delaware is most commonly used is that filings are easier and quicker in Delaware. In particular, while we are in the middle of a pandemic, there have been some delays in other states based on our experience in California, where we would submit a filing and there are some delays. However, Delaware is a very well-oiled machine. Our filings come back pretty quickly, and there isn't a huge delay when we do make any particular filings with the state of Delaware. There are also more predictable outcomes in the state of Delaware in terms of any law disputes, only because there's just so much case law that takes place in Delaware because a lot of companies do choose to incorporate there. So there's a lot of expertise and background in that particular space. Also, VC funds and angel investors will prefer that you incorporate in Delaware. And the corporate statutes are generally very flexible and company favorable in Delaware. So the most common corporate form that you would see is a C corporation. So in most cases, when a company refers to themselves as being a corporation, they're referring to being a C corporation. C corporations are subject to 2 levels of federal income tax. So they're taxed at the corporate level when income is earned, and they're also subject to income tax at a stockholder level when profits are distributed as dividends or other distributions to each stockholder. And this double taxation can be avoided if you elect to be treated as an S corporation. So an S corporation is a pass-through entity for U.S. federal income tax purposes. The S corporation does not pay an entity level tax. However, there are limitations to an S corporation. You're only authorized to issue 1 class of stock. You're limited to only having 100 shareholders, and your shareholders all have to be natural persons, so no entities or trust. And profits and losses are allocated proportionately.
Yeah, and for that reason, as you can imagine, an S-corp is not always the best vehicle to fundraise in, because investors who put money in want preferential rights, preferences, and privileges, which you won't get with just 1 class of stock.
So certain formalities need to be met in order to be in good standing. So once the entity has been formed, the formation documents have been drafted and executed, there are certain formalities that need to be in place in order to remain that good standing status. In terms of maintaining general corporate governance, typically a minute book is created where this particular minute book would store minutes of the board of directors, minutes of the stockholders, copies of the charter filings that the company has filed, a copy of the bylaws, a stock ledger, and copies of stock certificates that have been issued to shareholders. In addition to that, Delaware requires you to file an annual franchise tax, as well as a franchise tax in the state where you are doing business. And this is typically calculated based on the value of your corporate shares. And as mentioned earlier, if your company's principal place of business or where you plan to conduct business is outside of Delaware, you would typically then file a foreign qualification in order to do business in that particular state. So that's a separate filing that then needs to be made within that state. Another consideration is whether you need to file for a DBA. So a company is considered to be doing business outside of Delaware if it has some sort of nexus in a different state where it's conducting business, or if it's operating their business that's different from what is legally registered in the charter filing when you do form the corporation. Typically, and it's necessary for you to also open up a bank account for your business. Typically, what banks will require you to do is evidence that the company has been formed, so a charter filing, and sometimes they do request you to submit some corporate governance documents such as bylaws or an organizational consent showing that you've been formed and this has been approved by your board or shareholders. And separately from that, they typically do require you to also have your federal tax ID number associated with the entity when opening up the bank account. And lastly, you will also need an agent for service of process. So this particular individual is responsible for accepting legal documents on behalf of the company. So you will typically have to pay registered agent fees in order to receive legal correspondence if your business isn't located in Delaware. So moving on to employee incentives. So there are different ways in which a startup company can motivate and reward their employees. So we're going to touch upon stock grants and stock options. So stock grants give employees the right to receive shares once certain criteria is attained. For example, subject to a vesting schedule, whether you're working for a defined number of years or whether the certain individual is meeting certain performance targets. Stock grants are non-transferable and they're subject to forfeiture under certain conditions, such as if the employee is terminated from their job or whether they fail to meet any type of performance benchmark. The entire amount of the vested stock is declared actually as ordinary income in the year of vesting, and this is determined by by subtracting the original purchase price that was issued in connection with the stock grant minus the fair market value of the stock at the time that the stock becomes fully vested. So if the stockholder decides to then sell the vested stock at a later time, any difference between the sale price and the fair market value on the date of vesting is reported either as a capital gain or a loss. So in contrast, stock options are another benefit often associated with startup companies in order to reward early employees when and if the company ever does go public. And it also serves as an incentive for employees to stay with the company in order to vest in the stock that is granted to them. Stock options are typically granted through an equity compensation plan of the company. And it also gives the employee the right to buy the company's stock at a specific purchase price for a finite period of time. So as mentioned earlier with stock grants, there are vesting schedules associated with these stock option grants, and that limits the employee's ability to exercise, as they're typically only allowed to exercise when they're vested in the stock option grant. These stock option grants can be canceled once the employee leaves the company, and these stock options do not include any dividend or voting rights. Differing from the stock grants, the option grant itself is not a taxable event. Stock options are taxed when exercised, and stockholders will be taxed if they then eventually choose to sell the shares on the open market. So moving to intellectual property, and I will say LiLing and I are not IP attorneys, but we do have knowledge, a little bit of knowledge in this area, and we thought it was important as during the early stages of a business, it's important for a business to protect its core IP. So we thought it would be helpful to kind of cover 4 basic types of IP that a startup company should typically understand. So starting with patents. So patents protects your inventions, and there are different types of protections that are associated with the type of patent that you then choose to file. So the first type of patent is a utility patent. So utility patents protect processes that are created and machines. And any patent that is filed before June 1995 generally receives a 20-year term of protection from the filing date. Another area of patents which does receive a separate term of protection are design patents. So here, design patents provides protection for non-functional inventions. So any design patents that are filed on or after May 2015 receive a 15-year protection term from the issue date from the US Patent and Trademark Office. As of March 2013, patent priority is rewarded to the first inventor to file an application on an invention without regard to the actual invention date of when the invention was created. Moving on to trademarks. So trademarks protects the brand of your company, and a trademark can encompass words, symbols, logos, or slogans that are associated with your brand. And this protection lasts as long as the mark is used and maintained by the company. And this protection can only be acquired through the use of the actual trademark. Although registration is not required with the US Patent and Trademark Office, it does provide certain benefits. For example, on a federal level, it provides nationwide rights, and it also provides the company with the validity of ownership of the actual trademark. And in most cases with the companies that we've worked with, there's kind of a mixture of registered and unregistered trademarks. In terms of copyright, so copyrights protects artistic expression. And in order to gain that protection, the copyright needs to be disclosed in a public document. So after a copyright has been created after January 1978, this protection lasts for the life of the creator of the copyright plus an additional 70 years. And any copyrightable work that's created by employees or third-party contractors, typically referred to as a work for hire, those are protected the earlier of either 120 years from the creation of that copyright or 90 years from publication of the copyright. And so similar to trademarks, copyrights do not need to be registered, that's optional. However, if you do choose to register your copyright, it does then give you the ability to file a lawsuit for any copyright infringement. And lastly, trade secrets. So trade secrets encompasses IP rights or confidential information which may be sold or licensed. And in order to qualify as a trade secret, the information must be commercially valuable and also must be a secret and not known to a limited, only known to a limited group of individuals. This is protected by state law, and typically if any trade secrets or confidential information is being shared with a third party, we typically advise our clients to enter into an NDA or some type of proprietary information and inventions assignment agreement.
Yeah, I would say that Aimee and I usually work with specialists, IP specialists, to help craft an IP portfolio that makes sense to the company. And so, you know, that specialist will typically, you know, run through, you know, the different IP protections and think about sort of next steps moving forward. So, yeah.
Okay, so non-compete covenants are typically included in an employee's employment agreement. And it prevents that particular employee from working for a competitor or opening up a competing business for a specific period after leaving the company. These covenants typically protect sensitive business information such as a company's client list or any internal business plans that the company has. It also protects confidential information such as trade secrets and the company's IP. However, in order for these types of covenants to be actually enforced, there has to be reasonable restrictions in place in terms of time restrictions geographic scope restrictions, as well as adequate consideration in the employment agreement. However, because LiLing and I are practicing attorneys in California, we also did want to mention that non-competes in California are generally unenforceable. However, there are two exceptions to this. Non-compete covenants are enforceable if they're entered into in connection with the sale of a business, or if it intends to protect trade secrets of a company. So as mentioned earlier, I think there's a difference between trade secrets, confidential information, and proprietary information. So trade secrets is generally information that's not generally known to the public or to people outside of the company. Whereas confidential information is typically protected by entering into an NDA with a third party. And confidential information is typically defined to include all trade secrets and all confidential information that is then shared with this third party. But I do want to mention it's not just limited to IP, it could also be limited to documents or specific discussions that are then discussed with that particular third party. In terms of any proprietary information that is then shared, what we typically do see is as part of the package that employee signs when they do join the company is a proprietary information and inventions agreement. And so this covers, it's a broader category that covers both trade secrets and confidential information. So I think what's important to understand in these three kind of categories of information is you should always protect the trademarks and IP and confidential information of the company. And in order to do that, before sharing any information with a third party or even an employee relationship, you have to have the proper agreements and mechanisms in place to do that. So turning into our next topic, I'm going to provide kind of a brief overview on financing sources and the different types of fundraising, and then LiLing will then do a deeper dive into the terms and that are typically negotiated in these types of fundraisings. So as a starter, these are the three kind of buckets of individuals that you would typically see as players and as potential financing sources for the company. So the first bucket of individuals are angel investors. So these individuals typically invest in a startup, and I view them as individuals who just have spare cash and are just looking to invest in a startup company. And they kind of fill in the gap between a family and friends round and a more formal venture capital fund. Angel investors typically invest in the early stages of a startup company, so sometimes in a Series C round or a Series A round. And I think the main benefit from an angel investor for a startup company is the ability for them to seek advice or have the angel investor provide introductions that the startup company may not have. Angel investors typically just have a lot of expertise in a specific area, and they can then share that information and knowledge with the startup company. So it's important when you do start these relationships to determine what type of relationship you want to have with the angel investor, whether you have them join and be a board member or have board observer rights, or come on as a consultant. So these are kind of some things to think about as you are thinking about reaching out to angel investors. The second kind of bucket of financing sources are venture funds. So venture funds are typically part of a large institution, such as a pension fund or a financial firm or insurance company or university endowments. Venture money typically plays a role in the next stage of a startup's life. So when they're kind of ready for commercializing their innovation, they'll look to venture funds for bigger investments. However, it's also important to note that typically venture funds are looking for a return on their investment. and they will consider their own portfolio of investments before making this decision to actually invest in your startup company. And lastly, the last bucket of financing sources are corporate venture capital, so CVCs. So this is a form of venture capital where corporate funds are directly invested in external private companies. So they're typically managed and invested by a specialized division of a larger company. So think of Google. Google has Google Ventures, who typically invests in startup companies. Salesforce has their own individual CVC as well as Intel. So these larger companies have the main goal of basically investing in these startup companies dependent on what their business model is and what they're hoping to gain from these relationships. And typically the main goal of a CVC is to gain a competitive advantage or access to new and innovative companies that potentially could become a competitor of the CVC in the future. And what's great about these CVC relationships is the CVC typically has industry expertise. They also have a very prestigious, well-established brand that the startup company can kind of jump off of. They also have a network of connections, and typically CVC investments typically lead to a partnership between the CVC and the startup company, which then can instantly boost a company's value through that relationship. And next up, I will kind of provide a premiere to what LiLing will then be speaking to, but different types of fundraising. So here we're going to provide you with an overview on bridge financings and preferred stock financing. So two routes that a startup can typically take when it comes to bridge financing. They can either choose to go the debt route or the equity route. And typically startup companies prefer to do the debt route, whereas investors prefer to do the equity route. For an early stage startup company, a bridge round may be required or needed if enough money wasn't raised in a prior round or if revenue hasn't grown as expected. So they turn to a bridge trying to kind of get them afloat. And more often than not, bridge rounds are structured as convertible debt through the issuance of two different types of mechanisms. So convertible promissory notes and simple agreement for future equity. So in short, SAFEs. So convertible promissory notes are typically structured so that upon maturity of the convertible promissory note, typically tied to when the company then goes through their next round of financing, the note will then convert into equity shares. And typically this conversion happens at a discounted rate at the next round. And this discount rate can kind of range depending on what's negotiated in the term sheet. There are also valuation caps that may be added to the note. And the intention behind this valuation cap is to protect investors and if there are any type of unrecognizable gains that in the value of the startup during the bridge period. In contrast, another alternative to the convertible promissory note is a SAFE, and it's become highly popular. And it functions very similarly to a convertible promissory note. The investor makes a cash investment and then will be issued company stock at a later date when the next equity round takes place, and preferred shares are then issued. Similar to a convertible promissory note, a SAFE can have provisions for early exit, or if a company does dissolve. So there are certain protections in place. There are also preferential provisions to the investor as well, such as discounts and valuation caps that convertible promissory notes also have. However, the difference between a convertible promissory note and a SAFE is that a SAFE is not considered a debt instrument. So it doesn't accrue interest. It doesn't have a maturity date. And lastly, there's no minimum amount of fundraising that a startup must raise in order to have the SAFE convert in the next equity round. So then the next type of fundraising, equity financing. So typically for a startup who wants to avoid any type of high interest on any debt that's collected, they may turn to the equity route, which LiLing will go deeper into detail on this. But under this particular structure, the startup typically finds various financing sources. So it does, as discussed earlier, angel investors, venture funds, CVCs, to fund a preferred stock financing in exchange for equity ownership in the company, typically preferred stock.
Yeah, thanks, Aimee. And I would also sort of like say that in terms of safes, you know, Aimee and I have encountered this, you know, for example, companies that have done multiple rounds of safes and then come to us to help them work on, you know, corporate cleanup and other matters. And with safes, just because they're a lot more, they're less document intensive than a note, a convertible promissory note, it also means that it's not as robust in terms of, for example, if you want to amend a convertible note, chances are there is a provision in the note documentation that allows it to be, amendments to be made with the majority consent of the outstanding note holders. Whereas with safes, they're kind of designed as like one-off agreements. So if you wanted to make a change to the safes as a whole, you would need to get the individual consent of each safe holder. So if you're doing any changes to the safes, or which we saw in the company, you know, in a few companies that have come to us for corporate cleanup, you've kind of fundraised using multiple rounds of safe documents. Sometimes the safe documents don't take into account the fact that, you know, they'll get layered upon each other, and you really need to look at the conversion formula to see whether it accounts for multiple layers of safes. So that's just one caution I would say about safes, you know, that, you know, you really need to look at them, even though they seem very sort of like quick and easy to use and serve up to an investor. All right, so yeah, in terms of bridge financings, like Aimee had mentioned, you know, it's both convertible notes as well as safes. And it is a really flexible financing tool because it's a lot less document heavy than issuing stock. Just because right now, you know, an investor in a convertible debt will essentially not be a stockholder at this point, right? And so they're not negotiating all the rights, preferences, and privileges that come along with a series of preferred stock. So the company essentially eliminates all that negotiation back and forth between the investor and the company, and is able to take in the money, get the benefits of taking in the money, while essentially punting a lot of these questions about those rights at a later point when the convertible debt is converted. So yes, it's I guess these bridge financings are done at all stages of the company. As Aimee had mentioned, it's helpful in an earlier stage of the company where the company wants to take in the cash but doesn't want to deal with the documentation or, quite frankly, the attorney's fees that come with doing a full preferred stock round. And I think in this time of COVID especially, we're seeing a lot of companies go this route instead of doing a full preferred stock round. And that sort of like leads us to one of the points, which is like sort of valuation, right? If you are doing a stock round, you will need to place a price per share on the stock. Whereas for bridge financings for convertible debt, you're essentially dealing with that later on because the debt's converting at the next round of financing that triggers the conversion. So you're able to kind of push some of the issues of valuation down the road. As mentioned before, you know, some of the advantages are obviously how easy it is to document compared to a preferred stock financing. It also, as mentioned, you don't need to value the company as much. You're able to push a lot of those things down the road, even though you might have a cap on valuation, things like that, but still you don't need to price the per share stock at this point. And yeah, it gives the company currency that it can take in right now that will just roll into the Series A at a later point. So some of the main sort of components of a bridge loan, you're thinking about, discounts to that a holder will receive when it converts into stock. So, maybe they're getting a 20% or 15% discount off of what a Series A investor at that round would pay, perhaps, if it's converting at that point. Another way that a company can sort of entice an investor to participate in a bridge financing is to issue warrants. So I would, consider these sort of like sweeteners or kickers. And it basically gives the holder the ability, in addition to what they have in the note, the ability to buy stock of the company at a fixed price. And that price is usually, very investor favorable. So it sort of allows the investor the option to exercise the right to purchase shares at a later time. In terms of, for bridge loans, we tend to find that the warrants are very, very helpful. They definitely do provide a lot of incentive to participate in a bridge loan financing. And what we see in terms of warrant coverage may be, it varies, but we see sometimes, anything from like 10 to 100% warrant coverage. Definitely as company counsel, we try and limit the warrant coverage. And there are also times when I've seen investors sort of ask and negotiate for a sort of sliding scale of warrant coverage based on, when a round of financing is triggered, that triggers the conversion of the loan as well. All right, so the next, more, I guess, talked about type of financing is obviously a preferred stock financing. There's definitely a lot more back and forth between the company and investor in terms of negotiating, the rights, preferences, and privileges for each class of stock of the company. And some of the key components obviously include, the amount of offering. Usually the company kind of wants to define how much it's willing to sell and at what price. And price is determined by sort of the pre-money valuation, taking into account the capitalization table. So the capitalization table tells you, what's currently outstanding, with the company. And we'll talk about this a little bit later, but it's very, very important to make sure that you have a very tight and clean cap table. And when I say that, I mean that there are no sort of third-party outstanding claims to equity that are lingering out there, because it makes investors nervous, one. Two, it shows like a lack of like corporate controls within the company. And three, it affects, as mentioned here, the price of a round, because it's based on a company's cap table. And it very often sort of comes up in the context of young companies, especially where, certain equity is promised to a third-party independent contractor. And the relationship, and it was never sort of documented formally that what the independent contractor would accept as payment, especially if the relationship goes sour. So we want to make sure that you're able, you tie out a lot of these claims. And also sometimes, there might be, for example, emails between the company and an independent contractor promising certain number of shares, but it never gets sort of like tied out or closed out. So that's just sort of like a word of caution that, when you're thinking about equity in the company and keeping a clean cap table, you want to make sure that there are no outstanding claims for equity. And you can obviously work with your lawyers to make sure that the right documentation can be put in place in order to close out any outstanding claims. But sometimes if these claims have lingered for a long time, or the individuals are hard to track down, or they might refuse to sign certain documentation, that's when it raises issues or even red flags if the investors come to know of it when you're trying to do fundraising. Another sort of component to a preferred stock financing are obviously the identity of the investors. So I think Aimee had touched upon it earlier on about how, as the company sort of grows, who the investors will be will change. And here at a preferred stock round, a lot of times we'll see the VC money sort of come in at that point. And as also mentioned before, obviously more negotiation and documentation that will be required. We'll also sort of walk through this in our slides, the main documents that are used in a round of preferred stock financing and the different rights that attach in each of those documents as well. I will also say that for preferred stock financings, there are more conditions to close compared to a bridge financing. Due diligence tends to be a little bit heavier on a stock financing versus a bridge financing, particularly if you're dealing with definitely VCs, especially I've seen in my experience with CVCs, just because they have, they may be tied to a public company. And so they want to make sure that there are certain, that their investment is not being made in a company that doesn't have the right controls or doesn't have the right corporate processes that are needed to be put in place. So they tend to be, I found, very cautious. And so due diligence tends to be heavier when a CVC is involved. And there are other also, conditions to close, such as, putting together a disclosure schedule that is part of the stock purchase agreement and a preferred round of financing. Sometimes you'll have that in a bridge round too, but it tends to be less heavy and less negotiated than in a preferred stock financing. And that sort of goes hand in hand with the diligence, because if a investor wants to do heavier diligence, chances are they'll want heavier sort of reps and warranties that the company will be making regarding its operations, its IP, etc. And so as a result, the disclosure schedule which accompanies the reps and warranties will be a little like heavier, and there'll probably be more disclosures that are needed. And typically with also preferred stock financing, there are more formalities for closing, such as a certificate that's delivered by an officer of the company certifying that the conditions have been met, reps and warranties are accurate, things like that. Those sort of certificates are less likely to be found in a bridge financing, and so you can start to get a sense of how much more documentation a stock financing has compared to bridge financing. All right, so I would say, we're in the next couple of slides, we'll run through some of the main types of preferred stock financing documents. And the first one and the main one really is the certificate of incorporation. So this, or the charter. So this usually gets amended with every round of financing. So, there's a lot of eyes on this document. And it's a document that's filed with the Secretary of State and details the rights, preferences, and privileges of each class of stock of the company. And arguably, compared to some of the other docs, which are more contractual, you can say that because this document is filed with the Secretary of State, it may have like more force than even a contractual agreement between the parties. So, you know, in terms of if there are, you know, contradictions between something that's contractual and versus something that is in the charter being an organizational document and being filed with the Secretary of State carries more weight. So when you amend a charter for a round of financing, you know, there are a few sort of main considerations or points that are hit. So firstly, it's liquidation preference, right? So here, investors who are putting money in want to know how, in the event that there is an exit event of the company is bought, or there is some kind of other payout event, you want to make sure that you understand where you are in line when the money is paid out for that liquidation event. So there are two main ways to do it. One is for the preferred stockholders to sort of be at a higher level. They get their, you know, they get their preference paid out first, then the common stockholders get paid out after the payments to the preferred stockholders are satisfied. The other way to do it is for the preferred to get paid out their liquidation preference, and then they participate essentially with the common stockholders in receiving any payout. So you get essentially 2 bites of the apple. And you know, the liquidation preference, I would say, you know, is one of the more highly scrutinized like terms, and something you definitely want to focus on, because I think a lot of people are very cognizant about an exit event, and you know, and what that means for the investment. For dividends, it's also negotiated. I personally feel that, you know, liquidation preference is definitely much more important than dividends. And the reason why is that for a lot of these emerging companies, it's very rare that an emerging company will declare a dividend. Because, you know, the company is essentially growing. So any sort of extra capital is usually put towards, you know, growth of the company, and not towards, you know, giving a dividend out to its shareholders. So, you know, there, you know, you can get dividends. Usually as company side, I'd like to make sure that it's only when declared by the company. It's not something that just constantly and quietly accrues over time. Because unpaid dividends do get paid out in an exit event too. So that's something that I always try and track and keep in mind. The next thing is voting rights. And I think for voting rights, the main thing is the voting rights with respect to directors. So the charter usually lays out, you know, whether the Series A as a group, as its own class, is able to designate a director. Perhaps if it has, you know, a 3-person board, 1 of 3 directors, with the remaining 2 directors being able to be designated by the preferred and common voting together as a single class. So that is also a highly scrutinized area in terms of you know, the term sheet and negotiation between the parties in a preferred round of financing. I think that it also ties into the voting agreement that you'll see later on, where the parties contractually agree how they will vote their shares. But it's important to have it in the charter as well. The next thing is protective provisions. And these are provisions that provide a certain class of stock, typically, you know, the preferred stock with certain rights, certain veto rights, basically. So the company agrees that it will not do, you know, and provides like a list of things without seeking the consent of a certain threshold of preferred stockholders. And this usually relates to things like, you know, adversely changing the rights of the preferred stockholders, things like that. And those are fairly common, and also usually includes, you know, the ability, the need for consent if the company were to go out and do another round of preferred stock financing. Sometimes you'll see that, you may have certain investors sometimes ask for more operational type provisions, meaning, without seeking the consent of, the preferred, you can't do certain operational things like enter just certain kinds of agreements over a certain threshold amount, things like that. As company counsel, I generally try and push back on that just because as a young company, it's really tough to be hobbled so much by having a lot of these operational consent hoops that you need to jump through. So you want to make sure that the company is able to remain nimble and navigate its way through without too much additional requirements. The next one is anti-dilution provisions. So these are definitely also highly negotiated in the sense that whether or not they should be included, but generally the language tends to be, fairly standard if you decide to include them. Anti-dilution basically provides investors with protection if there's a down round. If stock is sold at a price that's lower than what they had bought it for, they essentially get some kind of benefit to make up for that fact. And there's a formula that goes into it that talks about how an adjustment to an investor getting anti-dilution protections, shares are adjusted. So that's definitely something that we see. I try and push it off if I can in early stages as company counsel. The last thing is conversion rights, and it's essentially just the conversion of preferred to common. Usually it's 1-to-1, unless certain events happen, and one of them being what happens if there's anti-dilution protection that needs to be had. So that's sort of the navigation of that. All right, so we've got the other preferred stock financing documents. I'll say here that it doesn't include a stock purchase agreement, which is also, I touched upon it earlier, an agreement that relates to that details the purchase of the stock, that has the reps and warranties of the company listed in it, and the company disclosure schedule. So, that is usually it doesn't provide as many rights for the investors in there. Sometimes you'll see some covenants or things like that, but these other documents, the IRA, the voting agreement, and the ROFR agreement, provide the rights that the investors are seeking. So for the IRA, here, it usually includes registration rights, the ability or the requirement for the company to be able to list its stock for public sale, the ability of an investor to be able to sell shares of the company if another investor or the company initiates a public sale of stock, information rights, which include certain financial rights that an investor might want, be it monthly, quarterly, or yearly. There's usually, it's very standard to have market standoff or lockup provisions, which basically an investor agrees to not sell its shares in the event of an impending IPO. So that's something that's very basic. Always include that in there, whether it's for sale of preferred or even common stock. And another common right are pro rata or preemptive rights, and this is also highly negotiated about the ability of a investor, and sometimes you can slice and dice it differently. It could be all preferred holders or major preferred holders, and you can define what that means and set a certain threshold for that, and talk about the ability of such, in preferred holder or major preferred holders' ability to keep their percentage interest in the company, such that if the company does do another round of financing, they're able to purchase up to a certain amount to keep their percentage interest. So that's something that definitely does come up in the IRA. One other sort of requirement that I also sometimes see in the IRA is that if there is, for example, the right of the Series A to designate their own director, the Series A director, sometimes in the IRA, you'll see, you'll have covenants at the back saying, without the consent of or the vote of the Series A director, you may not do, X, Y, and Z. And sometimes here I see more of these, what I would call operational type covenants, things relating to the operation of the company. You can't enter into, debt for X amount, or even leases for X amount, or any contractual agreements over X amount. And so that's where we'll sort of see those covenants. The next agreement is the voting agreement. Here, it's a contractual agreement essentially between the parties saying how they'll vote with respect to, one, the board of directors, and two, how they'll vote if there is a sale of the company and a drag along provision is invoked. So generally, because this is, it impacts like two very important things: the composition of the directors and what happens if a drag along provision is invoked. As company counsel, I always try and have, as many people sign on to this as well. This would mean that, common stockholders, even if they're not founders, but they're like major common stockholders, 1% or more for sure, they should sign on to this voting agreement, because you want to make sure as company counsel that as many of these parties agree to these conditions. So as touched upon before, the board of directors and who gets the size of it and who gets to designate directors is highly negotiated. And it's also contractually cemented here in the voting agreement, who can make those designations. And having the preferred stockholders as well as common stockholders agree to this. The second one is the drag along provision. So essentially, if the company's board of directors and a set number of stockholders agree that the sale of a company should go on, then all parties to the voting agreement agrees ahead of time that they will not contest it. And so this is especially helpful for companies here in California, if there are, certain dissenters' rights, things like that. A lot of times in the voting agreement, you have very robust provisions as company counsel, making sure that, shareholders can't contest the sale of the company and agree to go along, because you don't want sort of small shareholders being able to hold up a sale process. So this is more, a good protection for the company to ensure that everyone's on board, including the sort of lingering and smaller shareholders out there as well. The next agreement is the ROFR. So it's fairly common that investors want to make sure that the founders in particular stay with the company and are committed and vested to it. And so they want the right such that if the founders do sell their shares to another, to a third party, that they're able to sell their shares along with it on a pro rata basis. So sometimes I see this apply only to the founders. Sometimes I see it apply to other common stockholders as well. So it would be, founders plus, perhaps 1% or more holders. But definitely, at the very least, I see it with founders there. All right. So here are some sort of major legal pitfalls that we sort of see in term when we do these financings, and we may have touched on some of them as well. And I think So the first one is IP problems. And here, Aimee emphasized the importance of making sure that, that proprietary information and assignment agreements are signed. And the reason why is that you want to make, it's a very, very common rep in the purchase agreement that the company will give, that each of its employees and consultants have signed this proprietary information agreement. And the reason is that you want to make sure that any sort of IP that was developed by any consultant or employee done, for the company gets assigned to the company, especially, employees if they leave or independent consultants if they move on, they, may not be around to assign anything additional. So it's really, really important to make sure that each of those classes of individuals, employees and independent contractors, are signing these agreements. And I would say that I was in a round of financing representing a company. It was a Series B round, and the company had come to us only for this B round. So we hadn't represented them before. And there were, it was a CVC that was the investor. They were asking for the rep, as was pretty common that all employees and independent contractors had signed these agreements. And we couldn't make, the company couldn't make that rep. So eventually what we had to do was we negotiated a more defined rep, saying that all the independent contractors and employees who touched the IP signed this agreement, but they couldn't rep to the fact that everyone had. So these are issues that will come up in rounds of financing. So you want to make sure that those are sort of tied out and the investors don't have any lingering doubts about whether or not the company owns all of its IP. Along the same vein, I guess, is the founder's assignments, because the founder usually at the beginning, very early on in the company, will get stock in return for assigning, any IP the founder has developed up to that point, as well as moving forward. And sometimes, and it's usually in an exhibit to the actual stock purchase agreement itself that the founder is getting, and sometimes that just doesn't get signed. And that's also, again, it's really important that the company owns the IP that it purports to own, right? And so that's something that, we've seen founders, not execute it. Sometimes it's not because they don't want to, but it's definitely something that needs to be tracked down and included and make sure it's complete. Another kind of issue that we also see is in terms of compensation to employees and consultants, and especially here in California, being such a hot topic, is the classification of workers. So we've seen that there are times when emerging companies have improperly classified their workers as independent contractors when they really should be employees. And there are a lot of different, federal and state penalties in the event of a misclassification. So this is something that an emerging company should kind of just pay attention to. So for example, if a employee is classified as a independent contractor instead of an employee, because it generally tends to be cheaper for the company, that independent contractor may be able to, claim overtime wages, any sort of benefits that should have been offered to a employee that it should have gotten. And as you can imagine, if this happens over a long period of time, it kind of, the amounts accrue. And there's a claim against the company for this. And you're also actually entitled, or the worker is also entitled to attorney's fees as well. So, you know, these are areas that I would always make sure that emerging companies are mindful of as they go about their hiring practices. And it is a very evolving and dynamic area of law, you know, the classification of employees. So it's always good, you know, we definitely work with employment specialists in this area to help make sure that we're up to date and we can keep our clients up to date as well. Another area is, taxes, making sure that, you know, you're making the right taxes, especially any withholding taxes, employment-related taxes, just because there are, again, penalties and sometimes even criminal penalties that will attach if those are incorrectly done. So you want to make sure that you've got the right resources to make sure that you're handling this correctly. Another thing that we also sometimes, and thankfully, not in my case, the issue of defrauding creditors. So this happens when a company makes a payment to a shareholder, generally, when it's not supposed to. And when you say when it's not supposed to, it's because the company owes money to certain creditors before it can start making those, you know, distributions in the forms of dividends or anything like that, or stock redemptions to its shareholders. Each state has its own sort of corporate rule about when a company can make, you know, dividends. And so that's something else to keep in mind, you know, for the company as it goes, you know, as it makes promises or it deals with stockholders. It should also keep in mind the sort of like corporate restraints that it has to consider before it can, you know, give any stockholder like a dividend or buy back stock. All right, just checking for time. All right, so for other major legal pitfalls are the cap table, as we had mentioned, because, you know, if you're doing a preferred stock round of financing, the price per share is going to be based on the cap table. So you want to make sure that your cap table is tight and that there are no outstanding claims for equity. And it also gives the investors a lot of confidence that you're able to have good corporate governance measures in place. Another thing too is, you know, sort of considering, you know, who your investors will be. I would say, especially if you're dealing with, you know, individuals, and particularly if you're dealing with friends and family, you want to make sure that they understand the risks of these kinds of investments, and that generally it's a good rule of thumb that anybody who can't afford to lose their investment should not be allowed to invest. Companies should also just think too, when it's doing a, you know, round of financing, whether there's anything else that it should be informing the investor about that may, whether it's, you know, an actual fact, or maybe it's, you know, omitting to state a certain kind of fact. More disclosure to the investors is better, because you don't want the investor to be able to come back and say, oh, I would not have invested in the company if I had known about this. And so you want to make sure that you're staying clear of any claims like that, any claims for any kind of securities fraud, because if there are any issues, yeah, it definitely will affect the company's ability to raise money in the future. And the last one relates to generally like accredited investor status. So you want to make sure that your investors are the right kind of investors. Usually it's an accredited investor. Certain criteria needs to be met, so that you are not required to register your securities, the sale of your securities. You want to make sure that you always fall in an exemption for an emerging company. All right. So as far as liquidity opportunities, there are a lot of these are fairly well known. Obviously, an acquisition, merger or acquisition by a prospective buyer. IPO, very common here in in the Valley parlance. That's another exit opportunity. And the last one is secondary private market sales. So it's essentially the sale of by a shareholder. Usually it doesn't involve the company issuing new shares, but it's the sale by a shareholder to a buyer of a company's shares. And usually it's, a lot of times when I've seen it, and it doesn't always have to be this way, it can be preferred stock too. It can come in the form of a founder or some of the other employees, earlier employees, wanting to get a little bit of liquidity. So they're selling their common stock to an interested buyer and are able to, get some cash essentially for themselves. This usually happens where, it's the companies are staying private longer, not looking for an IPO type event, and the company is doing very well. So then it makes it very, more attractive for investors to come into the company this way as well. All right, so next one is, a few things to just keep in mind for a liquidity event. So one is create price drivers. I always am reminded of, so I have a good friend who's the Assistant General Counsel at Johnson & Johnson, Samir Desai, and he says that especially when he is thinking about a target, the management and their vision becomes very important and actually adds a lot of value to a company when they're looking to sell. And I think, in his case in particular, thinking about it more from a CVC point of view, it's usually a company that's looking to acquire a technology to buy the technology instead of building it in-house. And so if you have a management team that's great, that's dedicated, has a long-term plan to continue to develop it and will stay, that makes the company, the target, very, very attractive to a buyer. So definitely creating price drivers is important. Another thing too is having your corporate, your legal and operations house in order, making sure you've got the right documentation for everything. It gives the company the benefit of the doubt when it's dealing with a buyer. Aimee and I have seen this many times in companies that where we represent the sellers in an M&A transaction. So you definitely want to make sure that you've got documents for your arrangements, that those are executed, that you have copies of them, things like that. Knowing your stockholders is important too, just because you might have many different offers on the table. Maybe somebody is offering cash, another person's offering a mix of cash and equity. So understanding what your stockholders will want or get on board with will be very important, because as mentioned earlier, some classes of stock might have protective provisions, meaning certain events cannot happen without their permission. So you need to take that into account and think about, like, will I be able to get the consents I need in order to make this happen? Having a credible intellectual property position is definitely, it goes partly back to documentation and making sure that the company owns what it says it owns in terms of proprietary inventions agreements, assignments, founders, assigning things over, that you've documented well, any licenses in and out of the company, things like that. You definitely want to make sure that your key employees are incentivized during the process. I think Aimee and I have seen many deals where it's because these key employees will be doing a lot of the heavy lifting in making sure that the deal gets done, gets pushed through, that the documentation gets put together. And if there's no carrot for them to do this extra work, and it's because you're running the company while, you know, negotiating an exit event at the same time, you want to make sure that they are fully committed for the extra work and the ride as well. And so, you know, there are different ways that can happen. Sometimes, you know, it's like a cash bonus at closing, or employment agreements, or sometimes even maybe, you know, equity incentives as well. And so definitely a very important and very practical consideration for a liquidity event. And the last thing is what we call SOX. It goes to the general rule of making sure that you have the right proper corporate governance procedures in place, you know, the right documents and good financial statements as well. And particularly if you're going, you know, to go public, or if you are thinking about being acquired by a public company, those are very, you know, things that will be heavily considered by, you know, by the company in the IPO, or by a buyer in a M&A type situation. So definitely something good to focus on as well. All right, I think that brings us to the end of our presentation. That was, yeah, quite a bit. I mean, a lot of these sessions I think can be broken out into individual talks in their own right, but we tried to kind of very quickly give you an overview of you know, certain aspects of early stage financing and things to keep in mind.
Thank you very much. It's a very detailed and very valuable presentation. I think it's not an easy topic. Of course, legal is an important thing and you got to go into details. And since it's high level, yeah, it's a lot of work, of course. So we have some questions from people here and on live streaming. Nick Shilkin is asking, dear LiLing and Aimee, thanks for the very interesting webinar. Can you share with attendees some of the main model documents needed for C-corp, like the shareholders agreement with vesting, cap table, W7 and B605 forms, and so on?
Yes, actually, Aimee and I are part of at our firm, a group of attorneys who are putting together model documents for for basic formation. And we've got, we're working actually with the firm right now to upload those. So what we can do, I think, Danil, is once that happens, it should happen fairly soon. What we can do is we can send a link to you, and you know, you can direct people to those. Yeah.
Yeah, you can let me know, and then you just feel free to post it on our community in our global chat. I'll send you the link as well, so you just can you feel free to interact with the audience if you would like to as well. I have the other question about 83B election. Can you please elaborate about 83B election for founders and for employees? What's the difference, and what they need to know about that?
Yeah, Aimee, do you want to have a go, or?
Yeah, sure. So when a stock grant is issued to an employee or a founder, they are allowed to report the fair market value of those shares as ordinary income on the date that it's granted. And typically through an 83B election filing that's made with the IRS, it typically has to be made within 30 days of the date grant. The IRS is pretty strict about that. And so there are specific procedures that you need to follow when you're filing the 83B election that we typically advise our clients to do. So typically we it has to be an original signature on the A3B election. It has to be sent to the correct IRS location. So there are several IRS locations, and depending on where your residence is, you have to file to that specific address. And we then include like a transmittal letter with an extra copy of the A3B election, because we do like to receive a filed stamped copy back from the IRS, letting them know that they did receive the A3B election filing from the individual. So this then allows the IRS to know that the stock was issued at the fair market value at the date of grant, and that's in record.
All right, and so that applies to employees who are hired for like a tiny portion of equity, and they also need to do this filing within 30 days after they was granted this, or after they left the company?
So it's typically if a stock grant that is issued to an individual that is subject to vesting. So I think usually when you issue someone a grant, they're still currently an employee or affiliated with the company. And so you would have to do it 30 days within the date of issuing that specific stock option or stock grant.
All
Yeah,
right.
so it's not a stock option, but it's a stock grant. Yeah.
I see. And what about cliff? Some people don't understand cliff. Can you please explain the meaning of cliff and why and what it means for founders, for people working for a company? Sorry.
Oh, cleaves.
Cliff, you know, like cliff. This 1 year cliff.
Oh, Cliffy.
That's in schedule. Oh, okay. So typically what we do see when stock grants or even stock options are granted, there are different types of vesting schedules that are associated with the stock grant. So what we usually do see as standard vesting is a 4-year vesting and then a 1-year cliff. So what then happens is the stock option grantee or the stock grantee, after 1 year of the date of grant, they are then vested in 25% of that stock grant. And then after the 1 year surpasses, every month there is then monthly vesting on the remainder of the stock grant that is issued.
Thank you. Nick is asking, can you talk some words about crowdfunding in accordance with Title 3 of the Jobs Act? I'm not sure what is that.
Yeah. I would say crowdfunding is its own beast, and there's all these different restrictions around that. My sort of view is that if you go that route, it's very, very different than a more traditional, like emerging growth type route, where you're, progressing through different like series of financings. And I think also one thing with crowdfunding too is that, and I don't do that kind of work, is that it opens you up to a lot of like shareholders too. And so when you're trying to think about what your shareholder base is and accomplishing what you want, that, getting the right consents and things like that, as you're thinking about a liquidity event or anything like that, that's another consideration to take in mind. Yeah. But it's not a route that, any of the companies that I work with choose to go. Yeah.
Right. The other question from live stream, what about foreign investors on the cap table? Is it an issue? Does it bring any risks, like investors from Russia, from Asia, or from elsewhere?
Yeah, that's a good question. I think that it depends on the profile of your company, and it depends on what kind of investors you're looking to attract later. And it also depends on who these foreign investors are. I think strategically a company has to decide for itself how it wants to grow and where it wants to take money from. It's not uncommon for foreign investors to invest in emerging companies, and even the Form NVCA documents provide for that. But I would say it's more of a business decision and strategic one as to decide who you want your investor base to look like and how you'll be able to attract additional investment based on your current profile of investors.
Right, that makes sense. It's kind of a more strategic question, I would say. Yeah.
Yeah.
Daria White is asking, according to your experience, what is the most effective way or instrument of IP protection for IT startups in the United States? Patents, copyrights, or know-how? What strategy you can recommend, especially in the beginning when legal budget is low and risks are high?
I would, yeah, that's understood. I guess it would depend on what your IP is, right? Because obviously, you know, certain IP protections are not applicable to all kinds of IP, so it would depend. I think at the very least, those invention proprietary assignment agreements and confidentiality agreements are very important, because even if you're not getting any registered protection, at least contractually, you're holding people accountable to make sure that that company information stays confidential and that it's all assigned to the company. And so, yeah, I would say it would depend. You can also find, I would say, certain kind of niche boutiques that specialize in IP protection who might be able to do it at a very cost-effective price as well. If you're thinking about a patent, because I think that's, you know, something that's registered, you need to know the process, things like that. For other things like trademarks, you know, you can rely on common law or unregistered type protection as long as you continue to use it, and then maybe seek protection at a later time. So it would depend on the kind of IP you're talking about.
Yeah, understood. And I think from my perspective, what I've noticed as starting companies, as an entrepreneur starting companies, I've seen a good strategy just registering a provisional patent. If you need a patent, for example, it's not expensive and it's not like very much precise. Of course, there are some risks there, but it's pretty general, and it gives you 1 year of finalizing utility patent, which is more expensive, right?
Yeah, yeah, especially with the first to file kind of rule. Yeah.
Right.
Mm-hmm. Mm-hmm.
The other question we have, what is the difference of starting a company via clerky and via a corporate lawyer?
That's a good question. I guess we've seen companies sort of work with like base documents from, like that are pulled from offline or with other, non-legal, non-corporate lawyer type sources. And I think it really depends on what you're wanting to do with the company, because sometimes if things happen quickly, what we find we end up having to do, because we come in for the round of financing, for example, the company, gets formed, the founder, uses clerky or, some other kind of way to document corporate governance, and then, they're going to get a Series A round of financing, so that, we need some serious lawyers, so they hire us, and we actually spend a lot of time and money doing a lot of the cleanup sometimes, and it takes time, particularly, for example, if your inventions and assignments agreements weren't signed properly, and maybe those employees or consultants have moved on and you can't track them down, it can get very difficult. So for me, I always see it as, are you spending the money, later, or which might be more, or spend it a little bit earlier and make sure that everything is correct. Yeah, and I would say that you can, check with different firms as well, but, to ask about, different flexibility in fees and things like that too is another consideration, way to go about it.
Yeah, LiLing and I have had to do a lot of corporate cleanup for the clients that come to us that we didn't form them, we didn't help them through maybe their first bridge round, but they're ready to then do their first Series A financing. And so we tend to have to do a lot of cleanup, which obviously legal fees do add up. So when you loop in, a legal counsel early on in the process, us being able to share with you our expertise and templates and forms and processes that we typically have in place might save you a little bit of money if you're willing to spend in the beginning.
Yeah, it makes sense. Guys, if you have more questions, please ask them in the chat or raise your hand. We have 2 more questions, and I think we are preparing to wrapping this up. Peter Armand is asking why everybody chooses Delaware, why going public is the best from there or from Wyoming.
Do you want to take that, Aimee?
Yeah, sure. So Delaware corporation law is just something that's been very well established, and investors and angel investors are very familiar with that structure, and that's commonly why people choose to then incorporate in Delaware. Also, in starting a business in Delaware, there are very low franchise taxes there. So if you're thinking about tax implications or costs associated with where you want to form your company, those are considerations that people tend to keep in mind when they choose to incorporate. And on top of that, I think Delaware is very known to be a very company favorable state of incorporation. There's a lot of case law in place. There's a lot of precedent there where businesses are just typically favored there over employees.
Yeah, it's a Delaware specific thing, but they have courts of chancery there that just only deal with corporate type issues. And so as a result, like Aimee had mentioned, the corporate body of law is very well established. So people know have better certainty how things will flesh out, will be interpreted. And so it's kind of almost become like, a standard. And also the Delaware Secretary of State, where you do all of your filings, your corporate filings and things like that, runs like a corporation. I mean, that's what it's known for. It's very efficient. So for a lot of these rounds of financing, one of the last steps before investors will wire the money is they'll always say, show me proof of the filed charter. And if you finalize the documents that morning or the night before, being able to submit that filed charter to get the money in quickly makes a difference, whether it's one day, that same day, or many days. And in Delaware, you have all of these options to be able to get your charter back the same day, like 1 hour, few hours, things like that. So for that case, I know I personally have had frustrations filing with California at times, just because their turnaround times are not as good and less flexible.
Yeah, we recently had to file a charter in California because that's where the company, our client, wanted to form, and the current processing time was 2 to 3 weeks, and that was just a routine filing. In comparison, I think Delaware, you could do it the same day, you could do it in 2 hours. There's just lots more service processing times in Delaware compared to California.
Yeah.
And I guess this would be our final question. What are the best exit strategies you've seen?
The best exit strategies, like some good deals, like where
some tactics, or like you mentioned in the slides 3 of them, right? But how people implement that, how they plan it. So maybe you have some more information, just those 3 buckets,
Oh, Aimee, I mean, I think the ones where, so I think ones where the target itself has a lot of negotiating power. They have a very good they have a very good management team. I know I mentioned that before, but they have a very good management team in being able to drive the process and make decisions. and make sure that other key stakeholders get bought on to those decisions that are being made. They are good management in the sense that they've made sure that they have good financials, credible financials that make sense, that they've developed internal like corporate policies and internal checks to make sure that the companies run smoothly. Yeah, I mean, I think, and all of those manage, you know, and all of the very successful deals, I will say that the management has always been asked to stay on, to continue. You know, there's always a lot of incentives for the management to continue in their roles post-closing. And the companies that also manage to retain, where it's done, you know, I felt like it was a very smooth transition, was where the shareholders as well as management actually thought about the employees and thought about ways to make sure that the employees can still stay on after closing and provide the incentives for that, whether it's equity incentives or cash incentives or something like that. So I think it's like keeping everyone in mind to make sure that everyone feels good about the deal, essentially.
Yeah, I was gonna say sometimes I think companies get really excited when they have the offer on the table and they want to get to the end of the deal. But it's also really important to think 10 steps ahead in terms of what will be the big picture once we close. What would be the structure of the two entities when they do merge and come together? What do you envision that to be? Because everyone has a different perspective in terms of that, whether they want to keep their employees on, whether employees won't be returning. So it's good to look at the bigger picture and look at what in the future you see this type of collaboration being between the two companies.
Yeah, and if you're staying on as like high-level management after closing, it's like, what are certain rights that you want in place for you post-closing, where you can have the ability to make certain decisions, right? Where it's not completely left in somebody else's hands. So those are all things that you can negotiate and think about too. Mm-hmm.
All right, and that was LiLing and Aimee with this great presentation, very important information for you guys to start your businesses. LiLing and Aimee, I'll let you close this session, and if you have final words, please do so for our global entrepreneurs. People are really connecting from around the world.
Oh yeah, well, you know, thank you so much for tuning in today. I'll say that, you know, both Aimee and I have worked with a lot of emerging companies here in the US and abroad, and we've even done like a few deals where it was a international company flipping to become a Delaware company to take in money. And so we've seen like a few things, and we're happy to answer your questions. And I'm also happy, you know, either of us are happy to chat if you want to reach out to us individually with any additional questions. But we're glad we're here today.
Yeah, we appreciate the platform and allowing us to speak to everyone, and hopefully everyone enjoyed the presentation and it was helpful. And as LiLing mentioned, feel free to reach out to us if you have any questions. We're happy to help.
Thank you very much. And we will be happy to have you on our community as well if you would like to interact with our audience and probably give some advice, and maybe sometimes they will become your future client. That's also we'll be happy to have help you with that. And you never know, like first you need to connect with people, and I will send you the links later separately, and you are welcome to start communicating with our community as well. Thank you for your time. Thank you for a great presentation. I really enjoyed it. I'm sure the audience as well too. Thank you.
All right, thank you.
Yeah.
Thanks, you too. Take care.
Take care.
Bye.